Recently, a person shared a judgment with me and asked for my opinion on the same. And the judgment is from the Uttarakhand High Court. Before getting into the judgment, I request you to subscribe to this channel for more legal content and do click on the bell icon to keep posted. Now let us get back to the judgment. As I said, the judgment is from the Uttarakhand High Court. The cause title is Balraj Singh Lamba vs State of Uttarakhand. The case number is Criminal Revision number 201 of 2013. The judgment was pronounced on 23/12/2022. The core discussion that was made in this particular judgment was whether after the magistrate rejects or dismisses a petition made under section 156(3) of the Cr.P.C, can the informant approach the police with the same information, and can the police file an FIR and subsequently a charge sheet in that regard. Now, in this particular case, the informant had approached the magistrate and the magistrate had dismissed the same, saying the petitioner had oblique motives with which he or she had approached the magistrate under section 156(3). Subsequently, the informant within a number of days approached the police with the same information, and as observed by the High Court here, the complaint or the information given to the police was verbatim the same information given before the magistrate. Now here the informant concealed the information from the police that he or she had already approached the magistrate under 156(3) and the same was rejected. And since the police were not aware of such an order made by the magistrate before this, they registered the FIR and investigated. They filed a charge sheet. Now here the Uttarakhand High Court held that by concealing the order of rejection of her application under section 156(3) of the code, the informant got the FIR lodged. It further said that she filed the FIR, and by doing so she made the order of the magistrate dated 10/7/2012 redundant by deceitful means. It cannot be permitted to continue, and hence the court quashed the proceedings that came out of such an FIR. So when you read this particular order or this particular view that an informant cannot approach the police after the magistrate dismisses a petition under 156(3), you get a lot of questions, and the few questions that came up to my mind are: what if the informant does not conceal the fact that the magistrate had previously rejected a petition under section 156(3) of the Cr.P.C? If the informant does not conceal the information, if he is coming with clean hands to the police and saying, okay, the magistrate rejected a petition last week or last month, but I'm approaching you now, can the police register an FIR then? Are they bound by the magistrate's order? But we know generally that the police power to investigate is independent, and they have so many powers with respect to investigating into offences. So are they bound by a magistrate order under section 156(3)? That is one question. Now the second question is whether can we infer deceitful means or voluntary suppression merely because the informant has not conveyed to the police that he or she previously approached the magistrate under section 156(3) of the Cr.P.C. Now, with respect to this question, I want to put forth the proposition that one must remember that the informant might be a layman. He might be a party in person approaching the magistrate, and he might be coming back to the police. He or she may not be having the knowledge that there is a code here, there is a procedure here and all that, and that the person must be coming with clean hands. He has to give all details like I approached the magistrate last week or last month, so on and so forth. Will that by itself mean that the person has voluntarily suppressed any information? Can you give such an imputation, or can you make such an inference merely because the person probably forgot to inform the police or probably did not think that it was a very important information to be given to the police? Can you make an inference merely because the person did not convey the same to the police? That is the next question. The third question is, what if, irrespective of whether the informant concealed the information or not, the charge sheet reveals an offence? Now here, let us imagine this circumstance where after 156(3) is rejected, the police is being approached, the police registers an FIR, and subsequently a charge sheet is being filed. Now when the charge sheet is being challenged by the accused person before the High Court, stating, it comes out of an FIR that was registered in this background, and the same has to be quashed. But what if the prosecution side or the informant side is able to prove that the charge sheet has revealed an offence? The magistrate earlier dismissed the application thinking there was no offence made out, but right now the charge sheet reveals an offence. Now the High Court will necessarily have to look at the charge sheet, right? But obviously the Uttarakhand High Court did not go into the charge sheet material, but said that the very initiation of the proceedings, the registration of the FIR was based on the suppression of information. So the entire proceedings were quashed, but the charge sheet was not even discussed in this matter. The fourth question is, what if there were developments after the magistrate dismissed the petition under 156(3) and the police registers the FIR based on such developments? Obviously, in this particular case, the Uttarakhand High Court observed that the complaint made before the police had the same content as was made before the magistrate. So obviously in that circumstance you can say that there were no developments in that case. But what if in certain cases there are developments and the informant approaches the police subsequent to such developments? Now the next question is, what happens if the informant had made up such developments so as to convince the police to register an FIR? Now this is also an interesting question, because what if the informant thinks, okay, now the magistrate has rejected my application under 156(3). Now I want to improvise, add some developments and bring up some new stories into the complaint so that I can convince the police to register an FIR at least this time. Now who will be the appropriate authority or person to figure out whether the informant added these developments on purpose just to ensure that the police registers the FIR? Can the High Court use its inherent powers under 482 and hear this matter as to whether the informant improvised on purpose? I think so, yes. The High Court always has the power to look into the FIR, the surrounding circumstances, and quash the FIR or charge sheet coming out of it. But obviously here, I think in the Uttarakhand High Court judgment, the High Court must have looked into the charge sheet to determine as to whether the charge sheet revealed any offense or not. But what do you think about the same? Let me know your thoughts in the comment section as to whether the rejection of a 156(3) petition is binding on the police, and if the information reaches the police subsequently on some other date, can the police register an FIR whether or not they are aware of the fact that the magistrate has previously rejected a petition under 156(3). If you liked this video and if you want to listen to more judgments being discussed, more legal information, more interesting legal content, subscribe to Lawyer Society and click on the bell icon to keep posted. Thank you.